Picture this. You are walking out of a store. You have your bag. You have your receipt. You are thinking about nothing except getting to your car. And then a hand grabs your arm from behind, and a voice says, "Come with me." Your heart is pounding. Every instinct tells you to explain yourself, to apologize, to just make this stop. That instinct is about to get you in serious trouble. Because here is what almost nobody knows. The moment a private security guard makes physical contact with you without legal justification, they have not just crossed a line of decency, they have committed civil wrongs with specific legal names. Depending on how the contact happened, it may constitute battery, which is unlawful, harmful, or offensive physical contact. It may constitute false imprisonment through physical force. And if the guard acted without meeting the narrow legal threshold that permits any private security detention at all, every single thing they did after putting their hands on you is legally actionable. You do not fight back. You do not freeze. There are 6 words that force them to show their legal hand the instant they touch you, and 3 specific things you do afterward that build an unshakable case before you ever reach a courtroom. Today I am going to show you exactly what legal authority a security guard has to physically touch you, what the threshold is, and how rarely it is actually met, what specific civil wrongs occur when they cross that line, the exact words you say the moment physical contact happens, and the steps you take immediately after to build the record that wins. Hit subscribe right now because this channel exists to give you the knowledge that protects you at the most extreme moments of any encounter with private security. Share this with one person before this video ends, someone who shops regularly and would have no idea what to say or do if this happened to them. Here's the reality most people are never taught. Private security guards at retail stores, malls, and commercial venues are not law enforcement. In most states, they have no arrest power beyond that of any ordinary private citizen. Their authority to physically detain you is governed entirely by the shopkeeper's privilege, a narrow civil law doctrine that permits a retailer or their agent to briefly and reasonably detain a person when they have specific, articulable, reasonable grounds to believe that person has committed theft. Every word in that standard is doing legal work. Specific means connected to you individually, not a general suspicion about everyone in the store. Articulable means the guard can describe in precise factual terms what they observed. Reasonable means a court reviewing those facts would agree that a reasonable person in the guard's position could have drawn the same conclusion. Brief means the minimum time necessary to investigate, not however long the guard decides. And reasonable in manner means the detention method itself must be proportionate and non-injurious. Physical dragging is not reasonable in manner. Physical force applied without meeting the threshold first is not the shopkeeper's privilege at all. It is battery. Battery in civil law is the unlawful, harmful, or offensive touching of another person without their consent. The offensiveness standard is intentionally broad. Courts have found that grabbing, pulling, dragging, and physically forcing movement against someone's will all qualify. You do not need to be injured to have a battery claim. You need to have been touched in a way a reasonable person would find offensive, and that the toucher had no legal right to do. When a security guard drags you without meeting the shopkeeper's privilege threshold first, they have committed battery. When they use that physical force to prevent you from leaving, it is also false imprisonment through physical means. When their employer ratified or directed that conduct, the employer shares the liability. This is what most people do not know when they are being dragged through a store. They are not just being humiliated, they are accumulating legal claims with every step. Here is what the bad way looks like. Customer is grabbed by a security guard near a store exit and physically pulled toward a back office. The customer is shocked. They try to pull away. The guard tightens the grip. The customer eventually stops resisting and goes with the guard. In the back office, they are questioned for 30 minutes. Nothing is found. They are released. They are shaken, humiliated, and furious. But they said nothing during the incident that documented what happened, got no names, and within an hour, their memory of the exact sequence of events has already begun to blur. They have a strong civil claim sitting unused because they did not know what to do in the moment to preserve it. Here is what the good way looks like. Same situation. The instant the guard's hand touches her arm, before any pulling even starts, the customer says this, clearly, at a volume everyone nearby can hear. Am I being detained or am I free to go? That question forces the guard to commit to a legal position in front of witnesses. If he says she is free to go and keeps pulling anyway, he has just admitted on the record that this is not a lawful detention at all. If he says she is detained, the customer does not resist. She does not pull away, swing, or push back. But she keeps speaking, and she says this, I am not resisting, but I do not consent to this. You are physically forcing me to move. I have not been accused of any specific theft. I am stating for the record that this is unlawful physical contact, and I will be pursuing this legally. This is the combination that wins in court. The question that forces them to state their legal position, non-resistance, so there is no counter-argument about her own conduct, and verbal documentation the entire time. Together, that is a clean civil claim with no way for the store to argue she caused the escalation. Drop a comment right now and tell me, have you or someone you know ever been physically grabbed or forced to move by a security guard in a retail setting? Yes or no? Tell me what happened. I want to know how many people have experienced this without knowing they had legal claims sitting right there unused. If you are still here, hit the like button because what comes next is what most people completely skip. The 3 things you do in the 20 minutes after the incident that turn a claim into a case. Here is the 3-step documentation process that builds your case before you leave the parking lot. Step 1. Get names and numbers immediately. The moment the incident ends and you are no longer being physically restrained, you ask for and write down the name and badge number of every security employee involved. You ask for the name of the store manager on duty. You note the time, the date, and the specific location within the store where the physical contact occurred. If you cannot get the guard's name, describe them in detail in writing immediately. Height, build, uniform color, any visible name tag, radio position, anything identifying. This information is your ability to name defendants. Step 2. Find witnesses while they are still there. Look around. Other customers saw what happened. Employees saw what happened. You approach them calmly and you say this, you just witnessed what happened to me. I am going to be pursuing this legally, and I would like your contact information if you are willing to be a witness. Some people will say no. Some will say yes. One witness who will confirm what they saw changes the entire dynamic of any legal proceeding. Step 3. Record a detailed voice memo before you start your car. Do it in the parking lot before you call anyone. State everything in sequence. What you were doing when the guard approached, exactly what the guard said, the moment and manner of physical contact, what you said, what happened next, how long the contact lasted, what was said in any back office, who was present, when and how you were released. This contemporaneous record is among the most credible forms of evidence available in a civil case. Let me tell you about Renata. Renata is 44 years old, lives in Georgia, and was leaving a department store when a security guard grabbed her arm from behind without warning and pulled her toward a side corridor. She had made a purchase. She had a receipt. She had done nothing wrong. She was taken to a back room. She was questioned for 25 minutes. No theft was found. She was released without explanation or apology. On her way out, she was shaking and humiliated. She got in her car and drove home. 3 weeks later, she described the incident to a friend who had some legal background. The friend asked her several questions. Did you ask if you were being detained or free to go? No. Did you get the guard's name? No. Did you get any witnesses? No. Did you document what happened right afterward? No. Her friend told her she had almost certainly experienced battery and false imprisonment. Georgia courts have recognized civil claims arising from exactly this kind of retail security overreach. But the absence of any contemporaneous documentation meant the case rested entirely on Renata's word against the store's account of events. Without the 6 words and the 3-step documentation process, the claim existed but could not be built into a winning case. Renata now knows all of this. After this video, so do you. 2 legal foundations make everything in this video exact. Battery in civil law is the unlawful, harmful, or offensive contact with another person without their consent. Courts have found that grabbing, dragging, and physically forcing movement constitutes battery when the person doing it had no legal authority to make that contact. Physical dragging rarely meets the reasonable manner standard required by the shopkeeper's privilege. False imprisonment is the unlawful restraint of a person against their will without legal justification. Physical force that prevents movement is sufficient. A detention through physical contact in the absence of specific, articulable, reasonable grounds is false imprisonment. Courts have awarded significant damages in retail cases where physical force was used without meeting that threshold. Here is the complete recap. A security guard who physically grabs or drags you without first establishing the shopkeeper's privilege threshold has likely committed battery and false imprisonment. You do not resist physically. The instant they touch you, you say 6 words. Am I being detained or am I free to go? That forces them to commit to a legal position out loud. Then, whether or not they answer, you keep speaking for the record. I am not resisting, but I do not consent to this. You are physically forcing me to move. I have not been accused of any specific theft. I am stating for the record that this is unlawful physical contact and I will be pursuing this legally. Immediately after the incident, you get names and badge numbers, find witness contact information, and record a voice memo before you start your car. Those 3 steps turn a civil claim into a case. Think about one person in your life right now, someone who shops regularly and would have no idea what to say if a security guard put their hands on them. Share this video today, not later, right now. The 6 words and steps you just learned are the difference between a violation that goes unaddressed and one that wins in court. Next week, I am covering what happens when a cop knocks on your front door. What they can see from the doorstep, what changes the moment you open it, and the exact words you say through a closed door that keep every constitutional protection fully intact. Subscribe so you catch it the day it drops. Hit the like button if this changed what you will do the next time any security employee puts their hands on you. Drop a comment telling me whether you knew before today that physical contact by a security guard without legal justification is civil battery, regardless of whether you were injured. Know your rights, use them, stay safe.